Defendant.
Rainer Bonning is here for the defendant V Bass.
Thank you. All right, and do we want any opening statements, Mr. Alexander?
Well, just to review where we are, Your Honor, we filed a proceeding under 23A, Uniform Partition of Marriage Property Act. We've gotten to the point now of court's already resolved decree if the property cannot be partitioned in kind. It's a matter of whether or not the court will proceed with ordering the property sold on both market, either by agreement or whatever it's going to be. The defendant rather has claimed that, well, it's not, as he just said, it's not in fact heirs property, not because they didn't inherit it, but because there's an agreement somehow between the parties that binds them, that it is in effect a partition between them, or that they have no possessory interest. And so that's the sole issue for today, Your Honor. And we would ask after the court hears evidence that the court finds we're ready to proceed forward, order the property sold through either an agreed broker or one broker.
Thank you, Mr. Alexander. Mr. Monning, do you want to open now, or would you rather wait till the close of the plaintiff's evidence?
Judge, have you had a chance to look at the
Yes, I have read the defendant's bench book.
I will stand on the trial. I agree that we have to determine whether plaintiffs are tenants in common with the defendant and whether there is an agreement. They've got to prove there is no agreement in a record for the partition of the property. And I will say this, there are also in the event the court is to conclude that this is not heirs property, that raises our counterclaim seeking a declaratory judgment that we do hold a life estate in the property and requesting attorney's fees. Technically, that belongs to the final judgment, the judgment after there is the judgment declaring the ownership interest of property. But we're prepared to go ahead and prove that up now, or we can wait, because whichever way you rule, the rule is technically subject to an appeal to the Court of Appeals before we can proceed further.
Thank you, Mr. Monning. All right, Mr. Alexander, you ready to call your first witness? All right, and so Ms. Eubank, Mr. Alexander has called you as a witness. So what I'm going to ask you to do is you're going to want to find a place to sit down and move your device to where you can be comfortable. You're sitting down now. All right, I'm going to ask that I think you are not, excuse me, I'm sorry. Hang on. I'm going to ask you to unmute your device so I can hear you.
Okay,
All right, and so Ms. Eubank, can you see and hear me okay?
I sure can.
All right, and can you see and hear Mr. Alexander okay?
Pretty good.
Which one do you have difficulty with, the audio or the visual?
I don't see anybody but you.
Okay, and what that means to me is that you may have to move left or right on your iPad device, and then you will see more people. Or you may have to change your view to a gallery view rather than a speaker view.
Okay, just a minute.
You'll see one that shows the courtroom.
All I see is you and me.
Well, that's fine by me, but Mr. Alexander and Mr. Monty,
I don't know how I'm on live. Okay, okay, got it.
you've got him now.
Now then,
You see him
I
standing
can,
there?
yes, I can see him now.
All
Can you
right.
see me, George?
I can.
Okay.
All right.
The only question is an exhibit, how she will see.
We'll just have to hold it up to the camera. All right, so Ms. Eubank, if you will, raise your right hand. I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you may put your hand down. All right, go ahead, Mr. Alexander.
Joey, state your name for the record, please.
Joy Eubank.
All right, and you reside in Van Zandt County, is that correct?
Yes, I do.
All right, and you are who was your mother?
Barbara Bass.
All right, and how many siblings do you have?
There are 7 of us involved in this suit.
Originally, there were 7.
We have a sister who is deceased, but her family is involved.
Okay, name your siblings for me.
Okay, there is, the deceased was Margaret Inez DeVore, myself, Joy Eubank, Teddy Bass, Freddie Bass, Wanda Wise, and Denise Zamolik. Larry Bass. And Larry Bass, I'm sorry.
And you, Larry, Wanda, Gail, Denise, is the same as Denise, right?
Uh-huh.
Chris and let's see, there's
Teddy.
4 of you original children are plaintiffs aligned with you. Is that correct?
Pardon me?
There are 4 of you originals of the original 7 are plaintiffs, including you, in this lawsuit. Is that right?
No, there's 5. Wanda, myself, Denise, Larry, and Teddy.
Okay.
And the children of Inez have also signed.
I forgot Teddy. I apologize. So
Yeah, Teddy. And then Mark DeVore and Christy Traylor are also involved, and they have signed that they would like this all settled also.
they're the children of who?
They're the children of Margaret Inez DeVore.
And then there's the defendant is your brother, Freddie E. Bass, right?
Yes, uh-huh.
And your mother passed away when?
March 15, 1999.
Okay, and here in Van Zandt County?
Yes.
All right. And did she have a will that was probated?
No, I talked with Dean White, and he advised us that it was not necessary to probate the will, as she had nothing but the house until we decided to dispose of the house.
Okay. And the house in question is the property listed in this lawsuit.
Yes, 221 Gateway, Wills Point, Texas.
At the time of her death, she owned that real estate, and that's the only real estate she owned.
Yes, that's all.
All right. Let me show you what I've marked as plaintiff's exhibit number 1. Did you see?
You can put it right in front of that camera, and then you can.
Can you see this?
No, affidavit of heirship?
Yes,
Is
ma'am.
that, yes, uh-huh.
Okay, is this the affidavit of heirship that you and all of your siblings, even Margaret, before she died, all signed? Is that right?
Actually, Margaret didn't sign it. She's been dead for 8 years, but both of her children signed it.
Okay. And this was done through your attorney at the time and filed a record in the real property records of Van Zandt County. Is that correct?
Yes.
When did Margaret die?
She died January the 16th, 2013.
Okay. Correct me if I'm wrong, but I think she did sign this affidavit of heirship. Is that her signature on top?
I didn't think we did this affidavit of heirship until we decided to try to sell the house.
It was done back in October of '99, according to this document.
Well, her mom died.
The affidavit of heirship establishes the heirship of your mother.
Okay. Yes, that's right. I'm
We don't-
sorry. I was looking at the other one. Yes, she did sign this one. I was looking at the one that we worked on to give me the right to handle selling the house. Yes, I do have her signature on this affidavit of heirship. Yes.
You're talking about a power of attorney as opposed to.
Yes, I'm sorry. Yes.
We'd offer plaintiff's exhibit number 1.
No objection, thanks, Mike.
Thank you, Mr. Running. There being no objection, plaintiff's exhibit 1 is admitted into evidence.
And just to make it as quick and brief as possible, are you familiar with how your mother came to own the property?
Yes.
Originally? Okay.
Yes. She purchased it. Freddie bought it originally. He lived there for 1 year and made payments. Tommy and I loaned him the money for the down payment. So he made payments to us and to the mortgage company. When he got married, he could no longer afford that. So mother agreed to buy the house from him, assuming the loan from the mortgage company and assuming the note to Tommy and I.
Let me show you what is marked as.
Judge, this could be hard for the reader. Will stipulate, we have no objection to defendants exhibit 1 and 2.
You wish to call the defendants, that's all.
Yeah, in fact, they've already been filed with us.
So, all right, if so,
So
Your Honor,
it's-
we offer defendants exhibits 1 and 2.
All right, defendants exhibits 1 and 2 are admitted into evidence. And what are the names of those documents?
Defendants exhibit number 1, Your Honor, is a warranty deed dated October 29th, 1976 from Jerry Hooten to Freddie Earl Bass. And defendants exhibit number 2 is a warranty deed dated April 30th, 1980 from Freddie Earl Bass and Judy Bass and his wife Judy Bass to Barbara E. Bass.
All right, thank you.
Those admitted.
Yes, defendants 1 and 2 are admitted into evidence.
And so just for brevity, Joy, I've offered in the 2 exhibits, which are the 2 deeds that you just described, the transaction where your brother bought it originally and how it was financed, and then eventually your mother assumed or bought it from Freddie.
Yes.
Okay. So then, at the time that Freddie conveyed the property to your mother,
If you want to, just they're on the shelf.
who was living in the home at that point?
I'm sorry, when?
At the time that Freddie conveyed the property to your mother,
Barbara Bass and Denise, she was Denise Bass at the time.
That's your sister, one of the plaintiffs.
Yes,
So your mother and Denise lived in the home.
yes. Were you still in high school? I graduated in 76.
Joy, you can't talk to the other people in the room until.
Oh, I'm sorry. Okay.
So at that point, I mean, did that circumstance change at some point? Did anybody else move into the home?
No, it was just mother and Denise
And-
until Freddie got the divorce and moved back in with them.
Okay, when did that happen?
I think it was around 91.
Okay. And your mother, Denise, and Freddie all then lived in the home together?
Yes, Freddie eventually moved his daughter in with him at mother's house.
And was Denise still living there too?
Not at that time. She had graduated and was living in Forney.
Okay. So after Denise moved out, it was Freddie, your mother, and Freddie's daughter at some point.
Uh-huh. Yes.
And then how long did that circumstance, how long did that happen?
You know, I don't know how long Freddie lived there. Let's see. I'm trying to think when this all happened. He left his wife around 91, moved back into the house with mother. He eventually, let's see, moved Leah back in with mother when she was about 14, and she lived there until she was 20. I don't have dates on how long it was that he lived there.
When your mom passed away, what was the date when she passed away again?
She died March 15th, 1999.
Who was living at home at the time she passed away?
I think just Freddie and Leah were there then. We had to put mother in a nursing home. She had surgery and she had to go to a nursing home because it was a pretty serious surgery. And we brought her back home for a while, and then she had to go back in again after some more complications. And I believe at the time of her death, she died in Wills Point at Crestwood Nursing Home. And I believe Freddie and Leah were in the house by themselves at that time. The house was already paid for. So, you know, there was no mortgage or anything involved at that time.
And at the you discussed or stated earlier about your mother had a will, but you spoke with an attorney and was advised that it didn't need to be probated.
Yes, Dean White had told me after mother died, I asked him if we needed to do anything. And he said, since she has nothing except the house and she's left it to you children until you decide to sell it, there's really it's not necessary to probate it. So we chose not to probate it at that time.
Okay, and were all of the children, all the heirs, part of that conversation?
No, I was personal friends with Dean and Karen White, and I think I just had that conversation with Dean, maybe at his house.
Okay. Did you have any discussions with your brothers and sisters about the necessity to probate the will?
I had just discussed with them that I had talked with Dean, and he said it wasn't necessary to probate it.
And did you and your siblings discuss what to do with the property after your mother's death?
Well, we did, we just didn't really know what to do when she died. We were all kind of upset and nobody really wanted to make a decision at that time. And Freddie approached me and asked if he could stay there. And I said, well, you know, Freddie, it would not be fair to the rest of us for you to continue and to benefit from this house and us get nothing. And I said, you couldn't expect us to pay the taxes and insurance. He said, oh, no, I will pay the taxes and insurance. And I said, okay, until we decide to sell this house, that's what we'll do. So that's the only, we had nothing other than a verbal agreement. And he understood that the house would be sold someday.
Did Larry or Teddy, Wanda, Denise, or any other sisters, brothers and sisters, were they part of that conversation one way or another?
They were not there at that time, but they all knew that we had discussed it.
So did you have what the agreement or arrangement that you had with Freddie? Did you agree at any point in time to give up any possessory rights or any other rights in the property?
Oh, no, never. That was not Mother's desire.
Okay. Well, was it your desire, was it your intent to give up any rights in the property and arranging or allowing Freddie to continue to live in the home?
Oh, no, never. We were just doing him a favor.
Okay. And there was no term agreed to as to how many months or years he would live in the home?
No. I had just assured Mother that we would take care of, do what she wanted done, and she wanted each of her children to benefit from the house. And I assured her that that's what we would do. Everybody knew that.
And do you know whether or not Freddie has paid those taxes and insurance over the years?
Yes, he has. I've checked on that each year.
By my calculation, it's 21 years.
No, actually, Mother has been dead 22 years last Monday.
Oh, well, I guess that's right. 22. All right. So, but you checked on and periodically and found that Freddie was in fact doing what he agreed to do, and that is pay the taxes and the insurance.
Yes, in fact, I got notification each year on the insurance, and I checked with the tax office.
Was there any agreement between you and Freddie and your other brothers and sisters that at the point that the property would be sold, that he would be reimbursed?
Oh, no, never. That was his way of being able to stay in the house, was to pay that. Because otherwise we would have probably tried to either sell the house or rent it out.
And that's true for both the insurance and the taxes.
Yes, that he readily agreed to both of those.
Okay. And did you have any agreement with Freddie about, and this is after your mother passed, about if there was going to be maintenance or work done on the house? Did you have any kind of agreement about who would pay for that?
Actually, I don't think upkeep was ever really brought up. He just agreed to pay the taxes and insurance. And I don't remember that we ever discussed him doing anything,
Do you
which
know
he didn't. Pardon me?
all right. Do you know whether or not he did any significant maintenance, upgrade, or improvements to the property during this 22 years?
No, he did not. My sister Denise spent thousands of dollars replacing bathrooms, kitchen fixtures, flooring, porches. All of it was paid for by Denise.
Was that before or after your mom's death?
That was after mother died. Denise went through a divorce and she was having some financial problems. So she decided she would move back over there. So she moved in with Freddie and she began redoing the house because it was in dire need of repair, especially bathrooms. And so she moved in, I think, in 2007. And then she stayed there until about 2015. So over that period of time, she did thousands of dollars. And she did it because she considered that her place of residence, and it was not really very livable. So she paid out of pocket as she could to have each repair done.
So she lived there with Freddie from after your mother's death from 2007 through 2015 approximately.
Yeah, yes, uh-huh.
Anybody else that you know of lived in that home during the period of time other than Freddie and his daughter?
Freddie, well, yes, Niecy had one child with her.
Who did?
Denise had one child that came with her, her youngest daughter.
All right. Anybody else?
No, I think Callie lived there about 2 years, her daughter.
In this partition action, we are asking that the court eventually order the property sold. Is that right?
Yes.
Okay. And did you have any kind of written or recorded agreement with Freddie or any of the other brothers and sisters that granted Freddie some superior right to possession or ownership in the property?
No, only in his mind. About a year ago, my brother Larry approached Freddie and he said, you know, I need the money. I've got some medical issues. Freddie, we need to sell the house. And Freddie refused, said he did not have to, that he would make it very difficult for all of us if we tried to sell it. And that's when we decided we needed to get some legal assistance.
And that's why we're here today.
Yes.
Mr. Monning, before you begin, I should have done this at the outset for you, Ms. Eubank, and all of the subsequent witnesses that are going to testify today. It's very important that we each take our time and turn in talking. The attorneys are going to ask questions, let them finish their question, even though a lot of times we anticipate what they're asking and we want to begin our response. We need to make sure that there's ample time between the finishing of a question before we begin the response so that my court reporter here can take down a clear and accurate record of everything that's being spoken. So a good rule of thumb is to just take a moment, or actually just take a second or two to allow the attorneys to finish, to make sure they're finished. And then you can begin your response, and the attorneys are going to extend you the same courtesy. They're going to allow you to completely finish your answer before they ask the next question, so that my court reporter is not trying to figure out later who said what and when. Okay.
Okay, thank you.
All right, Mr. Munning, go ahead.
Ms. Eubank, I'm afraid of Ryan. We've met before, but we've never had a conversation before. Is that right?
I don't know that I've ever met you.
Okay. Maybe I didn't make a very good impression. You understand that I represent your brother Freddie.
Yes,
Now, there's no question but that your mother came to own the house at 221 Gateway under a deed that she received from Freddie. Is that right?
under what?
She was, Freddie deeded the house to your mother.
Oh, yes, yes,
And he deeded, under the deed recites that what she would pay for the house was she'd pay off the mortgage of the house.
yes,
And she eventually did that, is that right?
yes, she did.
And Freddie had purchased the house 4 years earlier from a fellow named Newton.
Yes,
And your lawyer has introduced the deed from Mr. Newton and his wife to Freddie. And it's marked, it says defendant's exhibit number 1. And there's nothing in that deed that says anything about any loan that Freddie received from you or from anyone else, is that?
I don't really know anything about that.
The deed speaks for itself. Whatever the deed says, it says. You agree with it, don't you?
Oh, yes, uh-huh.
And then when Freddie conveyed in defense exhibit number 2, the property to your mother, that deed also speaks for itself. What your mother did was she assumed the same loan that Freddie had assumed. Is that right?
Yes, she assumed both loans.
All right. And the amount of the loan that was assumed was originally $12,900.
Yes, one of them was.
Yes. And then, that's the only loan that's mentioned in the deed. Is that right?
Yes, the other loan was the down payment.
There's no mention in the deed of any down payment, is there?
No, that was a separate issue.
Sure, okay. And I don't want the court to be confused, but Freddie was in fact still living in the home on March the 15th, 1999, when your mother died.
Yes,
And Freddie and each other of your siblings all agreed that upon your mother's death, the property passed to all of you children. Is that right?
yes,
Now am I correct that you have really been the sibling other than Freddie, the sibling that has managed this lawsuit?
I'm sorry, I didn't understand that.
If you've been the one that's taken the laboring over in your efforts to try to sell this property.
I'm still not understanding what you're saying.
Well, let me make it a little easier. If you remember, when you and the other plaintiffs decided that you wanted to sell this property to someone else, you received the power of attorney from each of your siblings.
Yes, yes,
Your Honor, I'll offer the evidence, defendant's exhibit number 13. It's in your binder.
No, no objection.
All right, there being no objection to defendant's exhibit 13, it is admitted in evidence.
Exhibit number 13 is your response to a request for admissions that I served upon you and the other plaintiffs last year, isn't it?
I don't know if she has.
Well, and I'll just read exhibit 13 in the evidence. Request for admission number 3. Please admit or deny that plaintiffs Larry Bass, Teddy Bass, Wanda Wise, Gail Denise Damalik, Christy Taylor, and Mark DeVore gave plaintiff Joy L. Eubank their powers of attorney regarding the property, the subject of this suit. The response is admit. And the powers, when did they give you those powers of attorney?
The date. Are you talking about the date that they gave them? Just a minute. Ted's was signed December the 30th, 2019. Larry's December the 30th, 2019. Denise, December 28th. Wanda Wise, January the 13th, 2020. Christy Trailer, December 27th, 2019. Mark DeVore, December 30th, 2019.
Your Honor, I'll offer the evidence defendant's exhibit number 8, which is a copy of each of those powers of attorney.
No objection.
There being no objection to defendant's exhibit number 8, it is admitted in evidence.
So it'd be fair to say that you got those powers of attorney in the latter part of 2019.
Yes,
And from that point forward, under those powers of attorney, that is when you have admitted that you and all of your brothers and sisters, in response to the request for admissions, admitted that you had their power of attorney with respect to the property, the subject of this suit.
yes.
After you secured their power of attorney, you then wrote your brother Freddie a note asking him to also give you his power of attorney.
Yes,
And he declined to do that.
yes.
We'll offer defendant's exhibit 7 and defendant's exhibit number 9.
No objection. 7 or 9.
Defendant's exhibit 7 and 9 are admitted in evidence.
Okay. And in defendant's exhibit number 7, I'm going to show this to her. Okay.
You can hold it up to the camera like Mr. Alexander did. This little black camera right here.
There's defendant's exhibit number 7. That is the note that you sent to Freddie.
I can't read it, but I recognize my scribble.
Okay. And you gave him a power of attorney you wanted him to sign, which you had already signed and you put a little flag where you wanted him to sign. Right above his name.
Okay,
Okay, he didn't sign it.
I did not get it back, no.
Instead, what you received was a letter from me explaining to you that why Freddie is not going to sign.
Is that the letter dated January the 7th?
Yes, ma'am.
Okay, I've got it.
Okay. And at that time, you had the power of attorney for each of the other plaintiffs.
Yes,
Shortly after that, you wrote me a letter, didn't you?
yes, I did.
And in that letter, well, is that letter marked as defendant's exhibit number 10?
Yes,
All right. Well, defendant's 10.
This one's better.
Okay. We'll offer defendant's 10. No objection.
Defendant's exhibit number 10 is admitted in evidence.
All right. Is that your signature on the first page of exhibit number 10?
I don't know. I didn't look
This is
at
the
that.
letter of January 16, 2020.
January 16. I'm looking for the letter.
On screen.
Is it on the screen? Let's see.
Yes, sir. I'm sorry.
No, it's real blurry.
It's not very good. I can't see it.
January 16th, that's not
Are you talking about the January 16th letter that I wrote you?
Yes, ma'am.
Yes, okay, I found it.
And at that time, you were acting on your own behalf and under your power of attorney that you received from all of the other parties.
Yes,
And that is your signature on that document.
yes,
And you have a copy of it, and now the court has a copy of it.
yes,
And you provided to me what you call a timeline, or a summary statement.
yes.
Would you turn with me to page 2 of 3 of your summary statement?
Okay,
Now, that's a summary statement that you wrote and that you prepared.
yes,
And we looked at the bottom, and on March, you stated that on March the 15th, Barbara passed away.
yes,
And you consistent with your testimony, you said you were advised there's no need to probate it since only real property was involved.
yes.
Turn to the top of the next page.
Okay,
Now, you testified to Judge Martin that there was no agreement reached, but that other than that Freddie could stay there until y'all decided to sell the house.
yes,
That was after you filed this lawsuit. But before you filed the lawsuit, what you told me in that letter that you signed on the top of page 3, you said, since Freddie was single and living with Barbara at the time of her death, the other siblings agreed Freddie could continue to live in the house rent-free, provided he maintained it in good condition, repair, paid the property taxes, and kept the house insurance paid up. Those were your words, weren't they?
Yes,
There's nothing in there that says that he could only do it for so long as y'all didn't want to sell it.
I didn't think it was necessary to put that in there. We all, pardon me?
I appreciate it. There's nothing about for so long as that you can terminate that agreement at any time.
I did not put that in that letter, no.
And you testified that if there had been some agreement like that, you would have immediately sold the property, or at least you would have rented the property. That's what you testified to earlier this morning. There's nothing like that in what you wrote on
At the,
16th, 2020.
okay, can I speak now? At the time of the agreement, we agreed that he would live there, pay the taxes and the rent until we decided to dispose of the property.
And it's that last little phrase that I want to put out to you. That last little phrase there, until we decided otherwise, that is not what you said on January 16th of 2020, when you had the power of attorney for every one of the plaintiffs.
Well, I probably left out a lot of things in that letter. I was just trying to summarize it.
Okay, now, in fact, since your mother died, Freddie has paid all of the taxes, hasn't
Yes, he has.
he? And since your mother died, Freddie has maintained the house in good repair, hasn't he?
I don't know. I have not been in that house in years.
I request that the court take judicial notice of the appraiser's report that is on file with the court. It has photographs of the house, and it is darling and in perfect condition.
All right, the court will take judicial notice of the court-appointed appraiser's report filed in cause number 20-70.
And you'll agree with me that in accordance with that agreement, Freddie also kept the house insured.
Yes,
You haven't paid a nickel in taxes, and neither has any other folks.
no, we have not.
And now you testified that you certainly haven't paid for any repairs to the house since your mother died.
No, I have not.
And neither you nor the other plaintiffs have paid any insurance, have you?
I don't think so. I think Denise just paid for the repairs.
Appreciate you telling me that. You said that Denise did a lot of work, paid for a lot of work on the house. Is that right?
Yes, she paid for the repairs.
Now, how do you know she did that?
I have been there when the workers were there. I have seen her ordering the things. There's no doubt in my mind, she paid for everything.
Well, have you seen any documents showing that she actually paid for anything?
Yes, she's got receipt. She got, I don't know that she got receipts. She just got verbal agreements from people that she paid. What she had to go back, because that was years, to find out exactly, approximately what she paid on, say, for instance, the porch, the kitchen cabinets, the stove, oven, dishwasher, etc.
I'll offer defendant's exhibit number 12, Your Honor.
Any objection, Mr. Alexander? Defendant's Exhibit 12 appears to be the plaintiff's responses to defendant's request for production.
No objection, Your Honor. We haven't made a claim for reimbursement, so I'm not sure why I throw it, other than the fact that she didn't work.
Defendant's Exhibit 12 is admitted in evidence.
Now, Ms. Eubank, I requested that the plaintiffs produce any documents. The very first request was, please produce all documents reflecting any expenditure made by any plaintiff to insure the property the subject of this suit, and you said you had none. I asked that you produce any documents showing that you paid any ad valorem taxes, and you had none. And those are both true. You had none because none of you paid any of that, did you?
No, that was not our agreement.
Okay. And then I asked, please produce all documents reflecting any expenditure made by any plaintiff to maintain the property the subject of this suit. And you answered none, didn't you?
I thought I sent a copy of all the expenses that Denise had spent on this house.
Okay, but you didn't produce any in response to this request for production, did you?
Well, I don't know. I thought that this letter, this copy that she made was sent to you.
Nothing further.
Mr. Alexander, any additional questions from Ms. Eubank?
Eubank, going back to you have a copy of Mr. Monty's letter to you of January 7th, you talked about earlier.
Uh-huh. Yes. Just a minute. Okay, January 7th, yes.
A letter from Mr. Monty to you.
Yes.
And that was, what's your understanding of Mr. Monty responding to you? Why was he communicating with you?
He was acting on behalf of my brother Freddie.
Okay.
He says that Freddie purchased the property and that he continued to live in the house, claiming it as his homestead for over 20 years. He paid the mortgage on the property. He paid the taxes, and he made valuable improvements to the property. He's not interested in selling the house and respectfully declines the power of attorney.
So it was after you had asked Freddie to sign the power of attorney that you and Mr. Monty just talked about a minute ago.
Yes.
And anywhere in that letter does Mr. Monty or Freddie take the position that he has a life estate or some kind of agreement that he can live in the house indefinitely?
No, only that he had paid the mortgage on the property, which he did not.
And it says that he has paid the taxes on the property, which is true,
Yes.
because that's what y'all agreed to.
Yes, he agreed to the taxes and the insurance.
And then if you have your letter of January 6th, you and Mr. Monty just talked about,
Yes.
is a letter you wrote to Mr. Monty for what purpose?
I was just letting him know that Freddie had not been completely truthful with him. He did not pay the mortgage payments on that house. Mother paid that house in full, and he did not pay for the valuable improvements in the house, which he was claiming that he did. That was when I wrote back.
And you're on the top of page 3, you Mr. Monty went over your sentence. It says, since Freddie was single and living with Barbara at the time of her death, the other siblings agreed Freddie could continue to live in the house rent-free, provided he maintained it in good repair, paid the property taxes and kept the house insurance paid up. That's your statement, as you already testified to, correct?
Yes.
There's nothing in there that says it was going to be indefinite. There was nothing in that statement that says you were giving up any rights of any kind, nor your siblings of any kind in the property. Is that correct?
That's correct.
That's
Mr. Monty, any additional questions of Ms. Eubank?
In the letter that I sent to you, I did tell you that Freddie had been claiming the property as his homestead for 20 years. Is that what I say there?
Is that addressed to me?
In my letter to you of January 7th, I did say that he has continued to live in the house, claiming it as his homestead for over 20 years.
Yes, you said he has continued to live in the house, claiming it as his homestead for over 20 years.
And in fact, you testified earlier that you went down to the tax office and checked to be sure those taxes were paid from time to time.
Yes, I actually,
You know that he got his homestead exemption, don't you?
I did not know that until I met with Scott Hyde when all of this started. And he informed me that that's what was done. In fact, they had made a mistake, I think, when I filed the paperwork at the courthouse. At that time, the tax office was still in the courthouse. And the courthouse, I don't know how they did it. Scott corrected it, but he said they did not do their work properly, and they did not put mother's name where it was supposed to be.
Well, we will, with other witnesses, look at the tax bills that have been sent every year, and we'll see whose name was in. And we'll see whether or not it was homestead. But the fact of the matter is, you went to the tax office and had Freddie's name removed and put this property in your name, didn't you?
No, I think Scott put it in the heirs of Barbara Bass, maybe.
Okay. Judge, I'm sorry, it's cumbersome. I sent these to Mr. Alexander yesterday, but he didn't want, I would have done. He left it on his desk, so that's why I had to show him my original. So roll off for defendant's exhibit number 11.
no objection, Your Honor.
There being no objection to defendant's exhibit number 11, it's admitted into evidence.
And what you know is that the tax bill, after you went to the tax office, has it says Freddie Bass's name doesn't appear, does it? It appears, it has your name on it, doesn't it?
I really can't see it. I don't.
I'm just have to let the letter speak for itself. It says Joy Eubank and all. And we learned also what happened is the homestead exemption was deleted, wasn't it?
I wasn't aware of that until you told me that.
You don't know that as a result of that name change that you went down there and did, the tax went up over $1,000.
No, I did not know that.
But you do know that Freddie has paid those taxes, don't you?
Yes, he agreed to pay them every year.
Even after you went down there and had the name changed and you lost his tax exemption for homestead.
I only did what Scott Hyde said was supposed to be done.
That's news.
All right, thank you, Ms. Eubank. The attorneys have ceased their questioning of you at this time. Any additional witnesses, Mr. Alexander?
Joy, identify who's there with you.
I have my sister Denise Zamolik, Teddy Bass, and Freddie Bass. Excuse me, Larry Bass.
Who's sitting closest to you?
Okay, my sister is to my right. Right behind her is Teddy. And this is Larry directly behind me.
Can you turn the camera to Denise for me, please? Can you see me?
Can you see? Yes. Yes, sir.
Were you sworn in earlier or did you need to be sworn in?
She was- Are you going to call the rest of these witnesses? Just one more? All right. And it's Smolik, is that correct?
Zamalek, yes.
Malik, Ms. Malik, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I will. I do.
All right, you may put your hand down. And you heard the tips regarding your testimony that I gave to your sister, Miss Joy Eubank, correct?
Yes.
Okay, and if we can go ahead and move the camera a little bit more to just focus on you and less your brothers. Thank you. Okay, go ahead, Mr. Alexander.
You heard your sister Joy's testimony this morning, correct?
Yes, sir.
And I believe that the testimony was that you lived in the home. Well, let me ask you this. Did you live in the home or were you living in your mom's home at the time of her death?
No, sir.
You had moved out, you had married and moved out or were in school?
Yes, sir.
And after your mother's death, you did have a time period from 2007 to 2015 that you lived in the home.
Yes, sir.
Okay. And have you ever, from the point of your mother's death forward, have you ever had or made an agreement with Freddie that you were giving up your rights in the property in the home?
No, sir.
Did you ever agree to grant him in some form or fashion a life estate in the home?
No, sir.
Were you aware of the conversation or arrangement that Joy has testified about with Freddie that he could remain in the home after your mother's death as long as he would pay the taxes and insurance? Were you aware of that?
Yes, sir.
And you were okay with that?
Well, yes, sir.
And are you aware of any other written or recorded agreement between all of the parties granting Freddie some rights in the property?
No, sir.
That's it.
Mr. Monning, any questions of Ms. Smolik?
Yeah, just a couple of this, Zamali. In response to the last question, are you aware of any other agreement relating to the property? You will agree with me that there was an agreement relating to the property.
That there was an agreement?
There was
A
a
verbal-
agreement among all you and all of your siblings regarding the property and what would happen to it after your mother died.
All that was ever said was that Freddie could stay there, pay the taxes and the insurance until we decided to sell. And that was all that was ever said.
And what I'm confused about is, are you aware of any document limiting that agreement to something like until we decided to sell?
Now, I'm sorry, just tell me again, sir.
Well, we know there's a document that was signed by your sister with your power of attorney.
Yes, sir.
Your Honor, that's misconstrued of that letter. That letter was from Joy. Nowhere in that letter did it say I'm writing this letter on behalf of all of the siblings. It's not. It's a to do with power.
Well, I don't know.
Mischaracterization.
Let me call the question.
Okay, I'll sustain the objection.
You gave Joy your power of attorney,
Yes, sir.
and at the time that Joy had your power of attorney, she did write your brother a letter.
Yes, sir.
I don't know, did she send you a copy of that letter? Did she send them?
No, sir. I don't believe I have a, no.
But she was at that time authorized by you.
Yes,
With that property, wasn't she?
I'm sorry. Tell me, ask me again. I'm sorry.
You had given her your power of attorney with respect to this property at 221 Gateway.
Yes, sir.
Okay. Now, you do acknowledge that there is a document that describes the agreement that was reached after your mother's death.
Object to that characterization. There's a letter which is already in evidence of Joy's statement. Be clear. And there's no other document.
Would you like to clarify, Mr. Morning?
Well, was there a piece of paper? And I'm going to read from the Texas Property Code here. You are aware that there is a piece of paper that is inscribed on a tangible medium and that is stored in an electronic or other medium that is retrievable in perceivable form. Now, you have in that room with you a copy of your letter, the letter that your sister sent to me, don't you?
Yes, sir.
And that you can touch that, can't you?
And that what?
You can reach out and touch that letter. It's tangible.
Yes, sir.
And that letter includes a description of the agreement that's reached, doesn't it?
Yes, sir.
Okay. Now, you say that you lived in the home for what? About, you say for 5 years or 7 years?
It was, I moved in the home on December 8th, 2007, and I moved out of the home on February 14th, 2015.
And you didn't pay any taxes,
I did not.
and you didn't pay for any insurance.
I did not.
Nothing further, Judge.
Thank you, Mrs. Malik. Any additional witnesses, Mr. Alexander? Mr. Monning, would you like to call any witnesses at this time?
We're gonna call Leah Bass.
All right, Ms. Bass, if you'll come up to the witness stand. And before you have a seat right there, if you'll just raise your right hand and place your oath. Ms. Bass, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, just have a seat right there. And Ms. Bass, you've heard me admonish the other witnesses, make sure you speak up loudly and clearly for my court reporter so that she can take down what you say and extend the same courtesy that the attorneys are going to give to you. If they're asking a question, let them finish their question before you give a response. They're going to do the same for you. If at any time during your testimony, one of the attorneys objects or stands up, you'll just stop your testimony, let the court entertain the objection, and then I'll direct you further. And Bayla, can you come over and adjust this microphone for Miss Bass so that she can sit back comfortably? And we'll just lower that a little bit. It adjusts for her. There we go. Thank you. All right, Mr. Monty, you may proceed.
Your name is Leah Bass,
Yes,
and who's your father?
Freddie Bass,
And you were born when?
February 9th.
And you came home from the hospital, and where did you live?
With both of my parents in Edgewood,
And for how long did you live with both of your parents?
until I was about 13.
And what happened in 13?
My parents got a divorce.
And who did you live with after the divorce?
I lived with my mother for the first year.
And what happened? Do you know when they divorced?
I want to say it was 94, 95,
And you were how old then?
14.
And you lived with your mother for a year after the divorce?
Yes, sir.
What happened that caused you to cease living with your mother?
She abandoned me, basically.
And what year was that?
96, 95.
All right. And where did you go?
I went to live with my dad at my grandmother's house.
And that was, and then where did you attend school after you moved in with your dad?
Edgewood still.
And did you remain in the Edgewood schools until you graduated?
Yes, sir, I did.
And that was in what year was in, were you freshman, sophomore, or what were you?
I was a sophomore when I moved in.
And where, from the sophomore year through graduation, where did you go?
I lived in my house with my dad and my grandmother.
And who else was living there?
No one else.
When did you graduate?
1999.
And, well, and you graduated when in 1999?
May of 99,
When did your grandmother die?
March of 99.
And where was she living?
And I believe she was in the nursing home at
Okay,
that point.
do you know that? Was there a point in time during your sophomore, junior, senior year that your mother was also, your grandmother was also living there?
Oh, yes.
And so was there anyone living in that house with you and your dad other than your dad, you, and your grandmother?
No, sir.
What, if any, tradition did the Bass family have while your mother was living regarding Easter Sunday?
We always had a big family get together where all the brothers and sisters and nieces and nephews came for lunch.
And you were born in 1981.
Yes, sir.
Where was that family get together on Easter Sunday?
It would have been at my grandmother's house where my dad and I lived.
And that's the house subject to this lawsuit, 221 Mary.
Yes, sir.
Now, we can put it up on the calendar, but I'm going to ask you to assume that Easter Sunday in 1999 was after about March the 15th.
Yes, sir. Yes, sir.
Did that family tradition, tell us what happened to that family tradition on the Easter after you lost your grandmother?
It continued. We had a get together.
And was the family, whether or not there's a family there?
Yes, sir.
And what do you recall of any discussion with anybody regarding what are we going to do with the house?
Any discussion
was basically that my dad would continue living there as long as he kept up the insurance taxes and the maintenance on that property.
Now, do you know where your dad went to school?
Edgewood and West Point.
You know how far he got in school?
Yes, sir.
Did he think he get his degree?
No, sir.
What training has your dad had based upon your experience with him in matters such as accounting or bookkeeping?
No,
You know whether or not your dad ever managed a check?
no, sir, that's not.
Now, during your lifetime, what has your dad done for a living?
Worked retail grocery stores,
And which particular grocery store?
Butcher,
Where?
in Canton and West Point.
Okay. Now, what other jobs has he done?
A lot, mowed yards, cleaned up properties, worked for the bread company, the Gordons, worked for the movie theater, in West Point, just all kinds of side jobs just to make extra money.
Do you know where your dad deposited his paychecks when he got there?
Prior to me becoming an adult,
Yeah, like when you were a kid, when you moved in with him, as you were a sophomore in high school, you know, where your daddy bank,
he did not have his own bank account.
what did he do with his paycheck?
He would give any money that he has to his sister Denise.
And was this even before the sister Denise was living there?
Yes, that was.
And while it was just you, your grandmother, and your dad living on Gateway, who managed your dad's money for him?
Denise did.
How did your dad get your allowance, your lunch money?
He would keep some cash on it, but mainly he would give it to her. And if he needed some, he would ask her for money.
So before your grandmother died, I'm sure Denise was managing your dad's money.
Yes, sir.
And when or how long did you live in that house with daddy after your grandmother died?
Until I was about 20.
And you turned 20 in what? 2001? So you remained there after you graduated from high school.
Yes, sir.
What did you do after you graduated from high school?
I went to college and I worked.
Okay. And in 2021, you left, and who did you live with then?
In 2001,
Yes, ma'am.
I moved in with my ex-husband.
Okay.
He was my husband at the time.
And after you moved out and married your husband, did you assist your, who continued? Who was it that helped your dad with his finance, with his bank?
All due respect, I don't know that's relevant, that's financing, it's not issue.
This is gonna have something to do with the improvements made on the property. By Barb.
Yes.
All right, I'm gonna overrule the objection.
Did Denise continue to do
He
it?
did continue for a while, yes.
And was there ever a point in time at which your dad turned his financial affairs over to someone else?
Yes, he did,
Who was that?
myself.
When was that?
March of 2008.
And what happened?
Oh, I'm sorry.
You're very soft spoken.
Sorry. March of 2008, he turned it over to me.
Judge, I may have misread, I don't think there's a restriction in the Supreme Court order that requires that she remain masked. It might help. Can she remove your 6 feet away from it?
She's welcome to remove her mask. She doesn't have to have it on.
Oh, thank you so
Okay.
much. Yes, that will help.
I was worried about you sweating all over yourself.
You said in March of 2008.
Yeah, in March of 2008, what did you do?
I took over his finances.
And how did you do that?
He and I went down to the bank in town and opened up a joint checking account.
All right. What was your understanding as to why you had wanted to turn those affairs over?
At some point, he had asked his sister Denise for the money that he had been giving her, and she said there was not any left.
And since 2008, who has been handling your dad's financial affairs
Ah,
through today?
yes,
Who has been paying, seeing to the payments of insurance on the property and stuff that you have received?
I made the payments through his checking account.
Is defendant's exhibit number 3 a copy of the document that you, does that show the insurance that's been paid?
Yes, sir. it does.
Now, that document will offer through. No objection, Your Honor.
Defendant's Exhibit 3 is admitted in evidence.
Now, that's a document that only goes back 15 years. It doesn't go back to 1999.
Yes,
And that's because the insurance company doesn't keep records for 15.
correct.
And that reflects the amount of insurance that has been paid over those years.
Yes, sir.
Judge, I think I mistakenly attached exhibit 4. Exhibit 4 from exhibit. It's exhibit 4, a summary by year of the insurance payments that you took care of from your dad.
Yes, sir, it is.
Okay, through 2020, is that right?
Yes, sir.
And that shows that it shows the year that the payments were made, the amount that the payments were made, is that right?
Yes, sir, it does.
We'll offer defendants 4. No objection, Your Honor.
Defendant's 4 is admitted in evidence.
And it also shows interest on all of the payments that were made since that time at 5%.
Yes, sir.
How much insurance on that home have you paid? Has your dad paid at your age?
$17,482.
Well, is defendant's exhibit number 5 a copy of each of the ad valorem tax statements? Those are the receipts for payment, is that right?
Yes, sir.
And you may have to use your eyeglasses. I've got cheap and printed miniature versions. Each of those receipts shows who paid those taxes, doesn't it?
Yes, sir, it does.
And it says Freddie Bass, is that right?
Yes, sir, it does.
And Mr. Monning, you have the individual exhibits showing, because I'm not sure that anything on defendant's 5 is legible to the court.
Judge, I'll be happy. I agree with you. I can read it with my eyeglasses like this. I'll be happy to substitute in whatever it is. Oh,
Let me see that and see if I can even use a magnifying. Whose fingerprints? Yeah, this is illegible to me, even with a magnifying glass.
Judge, I'll substitute in full life-size copy of it.
Okay.
It's not listed.
Any objection to defendants 5? All right, defendants exhibit 5 is admitted into evidence.
And we'll offer defendants exhibit number 6.
Defendants exhibit 6 is admitted.
And it says defense exhibit number 6 is a summary of each of those tax payments that are included in exhibit number 5. And what is the total amount of taxes that your daddy has paid on the property since your grandmother's death?
$29,001.77.
Make sure you speak up, okay? You're soft spoken, and sometimes it's difficult because you're in a conversation with Mr. Monning, but Ms. Grisham here has to be able to hear you.
Leah, what if anything unusual has happened since this dispute arose with respect to the annual tax bill?
The name was changed.
But what is any, the taxes gone up?
Yes, they increased significantly,
How much did they go up?
over $1,000 at least.
And tell me whether or not you had, with your aid, paid those increased taxes.
Yes, sir.
Why did you pay those increased taxes on the tax bill and not try to dispute?
That was his responsibility to pay the taxes, so I paid him.
Nothing further.
Mr. Alexander, any questions for Ms. Bass?
Yes, Your Honor. Ms. Bass, so you were asked about this 1999 Easter Sunday, after, it would have been right after your grandma died.
Yes, sir.
So I think I wrote down exactly your words, but I believe you testified that the family that was there agreed that Freddie could continue to live there in the home, 221 Gatewood, if he paid the insurance, paid the taxes on the property.
Yes, sir. And upkeep.
And that's what he's done,
Yes, sir.
per the agreement.
Yes, sir.
So defendants. Three, 4, 5, 6, or 3, 5, maybe 6. Yeah, 3, 4, 5, and 6, which showed his payments of both insurance and taxes. He was fulfilling what he agreed to do.
Yes, sir.
In return for him living.
Yes, sir.
And I just want to be sure I'm clear on something. In March of 2008, that's when you took over helping your dad with his finances?
Yes, sir. Yes.
When you say took over helping him with his finances, does that mean you were actually contributing money to help him pay his bills, or you just helping him manage and pay him?
I just managed his finances.
You weren't giving him money.
No, sir.
And was there, and you said something about some money coming from Denise. Was Denise helping support your dad financially at some point in time? after your
No,
mom?
sir.
Okay. You were, when you said that the niece could no longer support him, it was helping him with his finances,
Correct,
not finance, money, not giving him money.
correct.
Okay. No further questions?
Any additional questions, Mr. Money? All right, Ms. Bass, you may step down.
And we'll call Frank Bass.
We're going to go ahead and take a recess at this time. I'm going to note for the record, it's 10:45. We'll resume court at 11 a.m.
May Leah be excused.
Any objection to Ms. Bass, Leah Bass? Ms. Bass, you're finally excused. Ms. Joy Eubank, Ms. Smolik, we're just going to stand in recess. So if you want to, you can turn off your camera and then we'll start back up here in about 15 minutes. You may be seated.
I left off one thing I need to recall this last.
Okay, before we do that, I'll just, and I believe that I'm assuming that Miss Eubank and the brothers and sister are still viewing. Their cameras turned off, so they'll be back. But do want to tell you, I do know how to read a clock. I do own a watch. I know I said 11 o'clock. I had an attorney come to meet with me that was going to take, as you know, 10 minutes. And it took 20. So my apologies for imposing on your time. So, all right, we are going to go back on the record, clause number 2070, Joy Eubank et al. Versus Freddie Bass and Miss Leah Bass. If you'll reapproach the witness stand. Ma'am, you were excused earlier. However, you're still in the courtroom. You understand that you're still under oath. All right, please have a seat. Go ahead, Mr. Monty.
And Ms. Bass, I've handed before you, it's exhibit number 10, which is the letter from Joy Eubank to me. And I want you to turn to the summary that's attached to that letter. Go to page 2 of 3 of that letter. Okay. You heard the testimony of Joy Eubank.
Yes, sir.
What, if any, recollection you have of any loan that Joy Eubank made to Freddie Bass? Your dad?
There's none that I'm aware of.
Of course, you weren't born when
Right.
she made it.
Right.
But is it, what mention has been made by any plaintiffs in this case of any loan of $2,500 from Denise's mom to your dad?
There was none to my dad.
Okay. And what about any loan of $1,000 from Joy Eubank to your dad?
None that I'm aware
Now, the family did agree, based upon your testimony, based upon the advice of the wife, not to probate the will.
of. Yes, that's correct.
I your pardon, the grandmother.
Yes,
That's your understanding.
yes, sir.
You weren't involved in that decision,
No, sir.
but your grandmother did have a will.
Yes, she did.
You seen that will?
Yes, I have.
What did that will say about a loan, anything about a loan from the niece, Fred?
Nothing to him.
What did that say about any loan from Joy, Fred?
Nothing.
Your grandmother, when she came down to the Win and Win Law Office, and what year did she make her will, you know?
I do not know.
Do you have a copy of it in front of you? Oh, here you go.
Oh, 1983.
When she came into my law office in 1983, she made a will. You've seen her will, haven't you?
Yes, sir, I have.
And did your grandmother in her will mention a loan of $2,500?
Yes, sir.
Being relevant, we have pled, nor are we seeking recovery for those amounts. It's not part of this lawsuit, it's not an issue.
The Ms. Eubank testified on direct examination about these loans.
That certainly may be true, but that was in response to a question from you, or maybe to me, but it doesn't make it, that's not, we're not pleading it, that's not, you don't have to dispute it.
A witness's truthfulness is always a question. She testified that she made a loan. She testified that Denise made a loan to Freddie. She put it in writing in her summary that Denise made a loan and Freddie made a loan. I'm entitled to introduce evidence to show that she didn't tell the truth. Her truthfulness is at the heart of this case.
All right, court will overrule the objection.
And grandmother's will, she said, pay all of my just debts, didn't she?
Yes, sir, she did.
And what did she include in her just debts of a loan in the amount of $2,500?
Says including any $2,500 loan from Denise Mullet and a $1,000 loan from Joy Eubank.
And those, according to your mother's, your grandmother's last will and testaments, were her just debts.
That's correct.
Nothing further.
Mr. Alexander,
Nothing further, Your Honor.
any objection to Ms. Leah Bass being finally excused? All right, Ms. Bass, you're free to go.
Do we want to wait on them? On them? Do you want to call them comments?
Let me prompt them to see. I anticipate they're there. We just may not be seeing them. All right, you may call your next witness, Mr. Martin. All right, Mr. Bass, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Please have a seat, get comfortable, lean back in that chair. We'll adjust the microphone for you. Make sure you speak up loudly and clearly, like I told all the other witnesses. Do your best to not speak over Mr. Monning or Mr. Alexander, and they're going to extend the same courtesy to you. And my court reporter here to your left, she needs to be able to hear you, so make sure you speak up loudly and clearly, okay? Go ahead, Mr. Monning.
Okay. Your mother was Barbara Bass?
Yes, sir.
When did your mother die?
March 15th, 1999,
And where was her home when she died?
221 Gateway Street.
And was that property subject to this lawsuit?
Yes, sir.
And how did your mother acquire it?
I bought the house to begin with, and then when I got married, she took over.
Now, the deed to you is in the record.
Yeah.
And it's exhibit number. From whom did you buy the property?
Jerry and Kay Hoop,
And where were you working in 1976?
Brooks and Wills Point.
For how long? How old were you in 1976?
I don't know.
Okay. When were you born?
54.
Let's assume you were either 23 or 24 years old. Is that right?
40. Yeah.
Depending on your birthday.
Yeah.
And what was your marital status when you bought that home?
Same.
How was it? With whom were you living at that time?
My mother.
And where were you living before you bought that home?
We was on Highway 80 in Miss Callaway's rent house.
All right. And how did you have come to purchase that home?
My friend Jerry Hoop at work, he asked me to take over payments on that house.
All right. And what did you pay for it?
I was paying $120 a month on that house, whatever the balance was.
And did you pay any of that money, Mr. Who?
No,
Who did you pay that money to?
to the bank on house payments.
All right. And so you bought that house for the balance over to the bank.
Yes,
How much was the balance?
11,000 so.
All right. But you didn't, you sold the home to your mother.
Mhm.
And how did you come to sell the home to your mother?
Because I was married and we was trying to get a home of our own, and they wasn't lending no money on, since that house was in my name.
All right. And you signed a deed to your mom 4 years after you bought it.
Yeah.
And your mom took over the remainder of the thing.
Yes, sir. Yes, sir.
Now, how did you happen to move back in with your mom?
I got a divorce,
And when was that? Do you remember?
95, I think.
And in your divorce, by the time you divorced in 95, did you and your wife own a home?
Yes,
Who got the home?
my wife,
Did you have any other home?
no,
And so you returned,
yeah,
and who was living there in that home at that time, when you returned in 1995?
My mother.
Your sister Joy testified that there was a meeting shortly after your mother died. What do you recall regarding the house? What do you recall of that meeting?
She just came to me and asked me if I wanted to stay there, I could, as long as I paid the taxes and insurance and kept the place up. She said, you can live here.
Did you hear Joy's testimony when she said you came to her and asked her
Yeah.
to do that?
I heard that.
What is your recollection of what actually happened?
I never went to her.
What happened and where did it happen?
Kitchen at the house where I'm at now.
What did Joy tell you?
She asked me if I wanted to live there, I could, if I pay the taxes, insurance, and keep the place up.
Now, what did you agree to?
I agreed to do that.
And tell the court what you did in order to fulfill that agreement.
I paid the taxes, the insurance, and kept it up. Improved it,
And what,
and improved it, you know.
Make sure you just speak up a little bit louder, okay?
and that was Easter 1999.
Yes, I'm assuming that. It was a weekend where it was all together at the house.
Over the course of the 22 years after that, when you have, the evidence is already in, that you paid the insurance, paid the taxes, you kept the property up. When, on what occasion, if any, did any of your brothers or sisters come to you saying that they had changed their mind?
No.
When is the first you heard of they wanted to sell the house and buy up the proceeds?
Last year when George started that.
And that is when, and what did you receive? How did you learn about what they wanted to do?
They just, they came to me, I mean, George sent word, we wanted to sell the house.
And that was, did you receive what I think is exhibit number 7, got that letter?
Yeah, the letter,
She wanted you to sign a power of attorney.
yes.
What did you do after you received that November 2019 note from Joy?
Took it to you.
Even after you received that letter, what did you do insofar as continue to keep the property insured, pay the taxes, and keep it, and keep maintaining the property?
Yes, sir.
I don't. Joy suggested in her testimony, I have perfect memory, but she suggested that there was some term limit on the agreement that you, how long you could stay in the house.
No.
And all of your brothers and sisters have a home,
Yes, they do.
and the only home you had was this home that you had bought,
Yes.
turned over to your mom,
Mhm.
okay,
Yes, sir.
and lived in it during the last years of her life.
Yes.
You know what did you, the value of this home in 1976, it's assumed it's what you paid for it.
Mm.
Is that right?
Yes.
11,000, how much?
500.
From time, you're familiar with the appraisal that the court now has, saying this property is worth how much?
Right now, I don't really know what it's worth.
I asked for a judicial notice that the court's appraiser placed the property at 100,000.
take a moment to review the court's file before there's no agreement on what the amount is. Give me just one moment.
We've agreed on, nobody, whatever it is.
And that's,
Well, the court will take judicial notice of the appraisal. I'm not gonna take notice of what the appraised amount is right now unless you tell me what it is and you agree.
and so the home is going up and back. What was your understanding is that how long you agree to maintain the property, insure it, and pay the taxes?
Yeah. So I asked for something, that's the way I understood it.
Nothing further.
Mr. Alexander, any questions for Mr. Bass?
Yes, sir. Thank you. Mr. Bass,
Yes, sir.
this conversation that you related to your attorney after your mother's death, is that it, and if I were, is that around Easter time when it occurred?
Yeah.
And that was just between you and Joy?
Yeah.
Regardless of who initiated the conversation, it was only between you and Joy? Yes?
Yes, sir.
And there's no written agreement between you, Joy, or anybody else with regards to your staying in the home, is that correct?
She wrote that thing.
Is there a written agreement that you have signed and all the other parties have signed?
No,
And when you initially were asked the question about the arrangement or agreement, she said, if I wanted to stay there, I could pay insurance, taxes, and maintenance on the home. That was your initial statement. And that was the entire agreement. And you agreed to do that, and you've done it.
yeah.
And in Joy's letter that you were just referred to Mr. Monty, the summary of the history of the property and the parties' involvement, Joy, when she cites the arrangement or the agreement, it's not inconsistent with what you're saying here today, and that is if you want to stay there, you pay the insurance, taxes, and maintenance. And that was the entire agreement, right?
Yeah.
There was nothing in her statement, nor in your original statement here this morning, that it was somehow had a term limit.
She said,
Isn't that
as long
correct,
as-
sir?
She said, as long as you want to stay here, you can stay here if you'll pay the taxes, insurance, and keep the place up.
And she didn't say that in her letter to your attorney, did she?
That's what I know.
And she didn't say that today in court, did she?
And sir, you're gonna have to speak up. My court reporter, she can't, I can hear you because we're close. He can hear you because he's looking at you, but
She
she's,
said there's a wall right here, and so I don't even see, I just see the top of his head.
so just speak up loudly, okay?
Joy didn't testify about any term limit today in her testimony, did she?
No,
And Denise didn't either, did she?
no.
So you're the only one taking that position out of all, what is there, 6 of you left? Or you know, is that right?
Yes.
Mr. Monty, any additional questions?
All of your brothers and sisters there in the home on Easter Sunday following Mother's Day.
Yes, sir. That was all in the
And
kitchen.
Joy came to you and made this statement to you.
Yes.
And 21 years later, she confirmed that agreement, did she?
Yes.
And 21 years later, she had secured the power of attorney from every one of your brothers and sisters and niece and nephew that are suing.
Yes,
And what she said was, since Freddie was single, and living with Barbara at the time of her death, the other siblings agreed that Freddie could continue to live in the house rent-free, provided he maintained it in good repair, paid the property taxes, and kept the house insurance paid up.
yes, sir.
Prior to her meeting with me toward the holidays in 2019, what occasion did you ever have to hear the term life estate? What occasion?
I'm sorry, what was your response?
I never heard it.
And what occasion prior to that time did you ever had to hear the term remainder interest?
No, I never heard that either.
Now, were you familiar with the term live?
Live?
Yes.
Yeah.
And you understand the term life,
Yes.
putting aside sectarianism. What happens after we live?
We died.
And she told you that you could live there. And what would happen when you stopped living there?
I was big gone.
And what would happen with this property?
Then it would be sold.
And what happened if you stopped maintaining the property?
Then it could be sold.
What happened if you didn't pay the taxes?
Same thing.
Even if the taxes go up $1,000 a year.
I made an agreement and I stood back.
And what would happen if you failed to pay, keep the house insured?
They would sell it.
Did you do everything that you agreed to do?
Yes, sir, I sure did.
And you're not dead yet?
No.
Nothing further.
Again, Mr. Bass, you don't have anything in writing from Joy or anybody else that says anything about the term of how long you're gonna live. Just
I just take people's word and she told me that I could stay there as long as I kept up the taxes.
okay, and she of course disputes that.
Oh, I know.
And so do all your other siblings.
Oh, I know that. Terrible. I know.
I mean, it's to your advantage to take that position and
I done what I was asked to do.
that's.
Nothing further.
May step down. Mr. Monty, any additional witnesses?
Yeah, Judge, there are two additional exhibits. I don't know that you want to get to them today because they're relevant only when it comes to final judgment. One exhibit is the interpretive service action real tables that value a life estate as compared to the remainder estate. That's material only in the event the property is sold and how you divide the proceeds. That is, if the court concludes that there is a life estate, but it needs to be sold anyway, that you have to apply those tables. And also, I have a counterclaim for declaratory judgment. I get attorney's fees on the declaratory judgment. I'm happy to prove them up now, or I'm happy to wait and let you look at the case and decide.
Let's wait. Let's wait.
We're gonna go through the list.
All right. Mr. Alexander, do you want to present any type of closing as to this stage?
Closing?
You've rested your evidence as to this issue, correct?
Right.
You want to go ahead and summarize the evidence as the court has received it?
Sure. Judge, as we have summarized at the very beginning, as you know, we started this proceeding, this partition suit, which is under 23A of Texas Property Code. We have agreed to the appointment of the appraiser to determine the value, which sort of skipped over the legal issue of that he pled, and that was that, well, this is not heirs property because there's some agreement that created that governs the partition. I mean, that's what the issue is. So we're kind of backing up, get back to that, which is all fine. Good thing. So the statute though, the statute specifically defines what is heirs property. Heirs property means real property held in tenancy in common that satisfies all the following requirements as of the filing of a partition act. There is no agreement in a record binding all the co-tenants that governs the partition of the property. B, one or more of the co-tenants acquire the title from a relative, whether living or deceased. And then it has some other qualifications that don't really, not really relevant here. There's no dispute, there's no contested evidence. Everybody has agreed that these people inherited from their mother. Their mother's will was not probated. There's an affidavit of heirship established with heirship. So the only question is there an agreement in a record binding all these other siblings of Freddie's to in some form that would prevent partition? And there isn't. First of all, let's just start with Freddie and go backwards. Freddie admits he didn't have an agreement. The only person he talked to about this agreement, this arrangement, was Joel. He's there's no evidence that there was an agreement among all the rest of them, regardless of whatever the terms of it were. Now, he wants to expand and twist words. There is nothing of record in a record from any of these folks that puts a time frame or limits or defines how long he's going to live. So I would submit to you, this is not an unusual situation where you've got 7 siblings and some of them want to be nice and let them live there for whatever period of time. But that doesn't, in essence, what he's asking you to do is wipe them out. And they get nothing unless he dies before any of them. And there's nothing to take such an inequitable position. The burden ought to be what it is. There's more than just, you've got the greater weight of evidence. And we know he never had a conversation with the rest of them. It's only Joy. And Joy's testimony has been consistent. Her testimony today is consistent with the letter that she wrote him on that day, wrote Mr. Money on that day. And they want to twist it around, but it's consistent. And so there is no binding agreement. There is no life estate. Nobody's testified that anybody, the plaintiffs testified that anybody agreed to give up any rights in this property by allowing him to live there. Nobody. So we believe the court should find that it is heirs property. It's subject to partition. But basically, if you find, the way I read statute, if you find this heirs property, then you're saying there's no agreement. So you're finding it's heirs property, then you're free to go forward. And the next step is to, again, as I said earlier, say to Mr. Monin and I, y'all want to agree on a broker, or you want me to want one? I suspect we can agree on one, but that's the next step. And then after it's sold, if we have any argument about proceeds from one thing or another, I recognize you made a claim for declaratory judgments. I think that's on the next stage. He's trying to, if you don't declare there's a life estate, I guess that's really the meat of this declaratory judgment. So you'd be in fact denying that they'd be found as the heirs property. The claim for reimbursement comes, I guess, later. I don't know that you're being asked, and Mr. Money disagree, and you're being asked to find
that there's X amount of dollars owed to Freddie today, reimbursement, we're doing that at the next stage, or you're not. So, I'll reserve any arguments about that till we get to that point. So that's what we've asked them to do, deny their relief, their claims. That it's not their problem.
Thank you, Mr. Alexander. Mr. Monty?
If we think back to the world in 1999, I'm not talking about Louisiana County, the state of Texas, or the entire United States. I'm talking about the world. The world view in 1999 was that the safest way to save is to buy real estate in the United States of America. Congress enacted new laws that made it easy for people to borrow money. Made it easy for banks to loan money. The mortgage market got absolutely bonkers crazy. Smart people in New York City created something called securitized mortgage loans, and they could mortgage $2 to $10 billion loans in a package and sell them to investors in Germany and China and across the world, because real estate was the best. The American real estate was the best investment in the world. It took us about 9 years to learn that was wrong. We all remember what happened in 2008. The world was wrong. Lenders sold too much property based on the assumption that it always goes up in value. But this family in 1999 thought the same way the rest of the world thought. The safest thing you can do is own a home in the United States of America. It will only go up in value. All of the members of Barbara Bass family had homes, except for Freddie. Freddie had transferred his home to his mother, provided she paid off an $11,000 mortgage that was on the property. That's all Freddie paid for the property in 1976. It was going up in value. It flattened out a little bit during the 2000s, and it continued after the recovery in 2009, 2010 to go up. It was a safe investment. They all have homes. It's a perfectly logical thing for children to do when their mother and father pass away, to leave that home to the child who doesn't have a home. It's the ultimate, in 1999, it's the ultimate savings account. My 1/7 interest in this home will increase in value. It will not cost me one dime. I won't pay any taxes. I won't pay any insurance. I won't have to keep it up. Freddie will take care of it, and he can live there. Now, George, Mr. Alexander has said there is nothing, no paper that limits the agreement. Well, I agree. There's no paper that limits the agreement. But the document that is signed, the document that is in writing, said that Freddie has the right to live there. I tried in my pretrial memorandum to cite Supreme Court cases only, because I think Supreme Court cases are the law in Texas. And I gave you 2 cases in there. Welch against somebody was the first Supreme Court case, and then there's another Supreme Court case where they said no particular words are necessary to create a life estate. People do that all the time. Freddie had never heard of the term life estate, never heard of the term remainder interest, but they did say Freddie could live there. What they didn't say was Freddie could live there for the time being, or Freddie could live there until we decide otherwise. They said Freddie can live there provided he remained there. And again, no particular words are necessary. What you do is, and this usually comes up in the context of will construction, but is applicable here. Lay people, in this case, formulated the creation of a life estate the same way that if we go back to law school, we remember that a deed is a mere substitute that lawyers created for the livery of Caesar. You remember back in property law when you learned from that aged professor how you transfer land. The perfect transfer of land is you go on the land, you bend down, you pick up a piece of earth, and you hand the earth. That is the perfect transfer of title. The absolute perfect way to do it. It's kind of romantic. It's also romantic here. And then that's what families do. They accommodate one another. They created a life estate. Now, when Freddie came to see me, he came to see me in December of 2019. There's no question about it. I told him, we got a problem. And we got to prove that all of your brothers and sisters agree to we've got to prove that all of your brothers and sisters agree that since Freddie was single and living apart at the time of her death, he could live in that house provided and keep it up and pay the taxes and pay the insurance. Okay? I told you it was real difficult getting all 7 of these people after they sued you. 2 of them weren't even alive at the time, that agreement. But that evaporated when Joy Eubank put it in writing. But Joy Eubank said that when Freddie was single and living alone at the time of her death, the other siblings agreed that Freddie could continue to live in the house rent-free, provided he maintained it in good repair, paid the property taxes, and kept the house insurance paid up. Your Honor, that's a life estate. Now, technically, it is a determinable life estate because it says he can live there, but it's determinable technically because if he fails to maintain it or pay the taxes or keep it insured, they can then, as remainder, come in. Now, we explained in our brief that the remainder have no standing to partition anything. They can't do it because it's possessory interests only. The chapter 23A, it says a couple of things. What it says is only tenants in common have standing to bring a partition action under the heirs statute. Well, they aren't tenants in common because the remainderman has no possessory interest. The remainderman has only the remainder after the termination of a prior possessory interest. That's just tenants in common 101. And the Hamilton, I forget which case it is, Houston Oil against Kirkendall, says that no, you must be tenants in common. All parties with the right of possession are the only parties to the property, whether it's a oil and gas well in Van Oil Field, or whether it's a little house on Gateway Street in Wilson, Texas. They have no right of possession, so they don't even have standing to bring the action. There, and if we look a little further, not only must there be proof that they are tenants in common, they need to prove that there is no record binding on all co-tenants that governs the partition of the property. Well, Mr. Alexander suggests, well, there's nothing on the file. Doesn't have to be on file because the Heirs Property Act defines what a record is. And a record, if in 23A/002(8) means information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perceivable form. You've got it. This is the record. It is a piece of paper that you can touch and feel. And what it says is all the other siblings agree. Now, that's hearsay. That's hearsay for her to say that, except at the time she made that statement, she had the power of attorney from every one of her brothers and sisters except Freddie, and from the niece and nephew of the deceased sister I danced. She had the power of attorney to do that. That statement, given that power of attorney, that they had surrendered to her, is binding upon them. You look at the request for admissions. Exhibit number 13. We asked them to accept or deny that plaintiffs gave Joy Eubank their powers of attorney regarding the property subject of this suit, and they admitted that. That issue's over. That's what requests for admissions do. They cannot contest our contention that they gave Joy their power of attorney. And when did they give them their power of attorney? Joy testified in November and December of 2019. That record, that statement regarding the agreement was sent in January of 2020, after she had their power of attorney. You know, and let me just comment briefly on something that's going to come up. And the reason why our courts and the English courts before us concluded that partition it was originally a benevolent remedy. Now it's statutory. But the notion came up that only parties holding a possessory interest in land are entitled to partition. The reason for that is it's kind of hard to value a reversionary interest. What happens after if two people that have contingent interests or future interests? What happens is you've got to figure out if you do partition it by sale, for sure. You've got to figure out what's the property worth. And if we got to that point, we've got Defendant's Exhibit 14. It's a self-proving document. It's the IRS tables. Would we value sales of property out of the states in which there is both a life estate and a remainder interest? And under the IRS tables, the life estate in this property for 67-year-old Freddie is worth 51% of the total value of the property, and the remainder interest is worth 49%. So if this property should sell for $140,000, Freddie's going to get $70,000 because his right to live there and continue to pay the taxes under this agreement is worth 51%. But it gets even curiouser than that, because when you look and see in a partition, a co-tenant is entitled to recover the amount of taxes and insurance and improvements that he's paid. And you can see that Freddie is not only going to get that $70,000, 51% according to the tax tables, he's going to get $23,000 for the insurance payments that he's made, and he's going to get $44,000 to reimburse for the taxes he's paid. What is that? $57,000, $67,000. Freddie's going to get, if you can partition out a life estate, Freddie here, and have to pay the people their value of their property, Freddie's going to get all but $6,000 from the proceeds of a $140,000 sale. That's what happens. But it can't happen because the Supreme Court, the courts in England, the courts of every other state says, no, you cannot partition. A non-owner, non-possessory owner cannot partition. And the good reason is sometimes they get what they ask for and they're not going to get much. Freddie wants to abide by his agreement that you've got in writing from the holder of the power of attorney in all the plans. And this case, we should be dismissed, and Freddie is entitled to a declaratory injunction that confirms that this document constitutes the creation of a life estate followed by a remainder interest in all the children who descendants of Barbara Bass.
Thank you, Mr. Ryan.
In all due respect, that is such a huge stretch of the terms of the law that apply to this case. First of all, there is no evidence to support the beginning of this statement about what the family members wanted or what they thought or what their intents were about owning and holding property. There's no evidence of that at all. There is no evidence that they all thought, well, I have a home, so maybe Freddie should have a home too. And I'll just give up my inheritance. There's no evidence of that. Barbara Bass's will doesn't leave the property to Freddie. So if that was her intent, then why did she leave the will and say it? I mean, he'd have probated the will, that's what it said, because they all got it, right? So that's not the case. And the case law that's submitted, I mean, you may have already read it, but those cases are distinguishable. The first couple of three are dealing with mineral interests, and they're distinguishable, but they're not anywhere close to this case, but they're talking about mineral interests, life estate, how you reside. In the last couple of cases, they're talking about interpreting the language in a wills, to a couple of those cases. So, they're distinguishable from this situation. And he's asking you to stretch that, the summary letter that Joy brought, and somehow make that an agreement on behalf of all of them, where she never, that was not the intent of her. If you read the letter, I'm sure you have, wasn't her intent, first of all, given general summary background. And her testimony today was consistent with that. But there's nothing in that letter that says that she's writing this letter with authority from her sisters and brothers and making this statement to bind them, which is what you have to do if you're the power of attorney. And to stretch that so far is so inequitable to these other parties. We ask you to deny it.
Thank you, Mr. Alexander. All right, court's going to stand in recess for the lunch hour, and then typically we would resume at 1:30. However, I want to have an opportunity to ponder the evidence that I've received today. I do want to look at these cases again. So let's resume at 2 p.m. this afternoon. We're going to stand in recess for the lunch hour, and then we're going to resume at 2 p.m.
Witnesses, excuse me.
Witnesses are excused, yes. And so those who are appearing via Zoom, I'm going to leave this up so that if you just want to leave your device on, it will still be on at 2 p.m. All right, but I would invite you to turn off make sure your microphone's turned off and your camera.